Good afternoon and welcome to the Stop Abuse Campaign's first Facebook Live event. For those of you who joined us yesterday, you might think it's our second, but hopefully this one will be a lot more successful. I'm Andrew Willis, the founder of the campaign, and my job today is to introduce Melanie Blow, our new executive director. Welcome, Melanie. I'll leave you to your conversation with Barry and our new video about the family court custody crisis. Thank you very much.
Oh, thank you very much, Andrew. So today we're going to be talking with Barry Goldstein, who is our resident custody court expert, and he has brought us over the years a huge amount of perspective and information about why the family courts are the way they are, and even more importantly, about what we can do to fix them. Before I introduce Barry, I'd also like to talk I'd like to introduce us. The Stop Abuse Campaign is an organization. We believe in preventing adverse childhood experiences through public education and public policy. We believe in evidence-based practices. We believe in research and innovation. We are a trauma-informed organization, and we believe in individual dignity of survivors, of children, and of all the rest of us. So I want to just explain a little bit about why and how we made this video. So we are always in contact with protective mothers who struggle to explain what's going on in their life, explain what's going on with their children, explain what's going on in the courtroom to people, because the stuff that happens in custody court really and truly can just defy belief. It defies common sense, and the stories are very, very complex and very terrible. So one of the things that we realized is we just need a simplified way of talking about custody courts to the world. We need a way so that protective mothers can just explain in very, very simple ways, what's going on. Why is court taking so much out of your life? What's going on with the kids? So we had some volunteers, some wonderful volunteers, write the script for this video, write it, do the voiceover, the whole thing. We're finding it a great little tool, and right now it is available on our Facebook page and on our YouTube channel. So we encourage people to download it and share it over social media to help explain what you're going through a little bit better and to just raise awareness about this, because one of the obstacles to fixing this problem is a general lack of awareness. So without any further ado, let's roll the video.
There's a crisis right now in America that's having a devastating impact on the health and safety of our children, but it has largely gone unnoticed. In the past decade, close to 800 children have been murdered by an abusive parent after being awarded custody and visitation rights by family law court judges. Currently, family law courts in the United States send approximately 58,000 children a year back into the homes of an abusive parent. How is this happening? Well, since the 1980s, family law courts have been built around a flawed and dangerous theory, now debunked, that assumes that most reports of domestic violence and abuse are false. But surely family law courts are there to protect our children from abusive parents. In theory, yes. However, although our understanding of the extent of domestic violence has progressed since the 80s, sadly, the family law court system is still entrenched in an outdated bias that favors the rights of the abuser over the rights of our children. As a result, acts of protection have become greater crimes in family law courts than acts of abuse. And for the parents seeking protection for their abused children, this flawed thinking has become an insurmountable obstacle to securing their family's safety. What can you do to help? Current research from the Center for Disease Control has revealed the devastating impact of adverse childhood experiences, or ACEs, on the health, safety, and well-being of our children. By requiring family law courts to follow current scientific research, we can ensure that vulnerable children remain in the homes of protective parents, reducing their exposure to ACEs and giving them the opportunity to lead safer and healthier lives. The Stop Abuse campaign is working to pass the Safe Child Act, giving family law courts all the tools they need to make sound, child-centered custody decisions based on up-to-date scientific study rather than antiquated and inaccurate opinions. To find out more about the Safe Child Act and the research behind our campaign, please visit our website at stopabusecampaign.org. You can learn more about current family law court practices, how this legislation will work, how you can donate much-needed funds, and how you can join our team of volunteers working across the country to pass the Safe Child Act. And with close to 800 avoidable childhood deaths in the past decade, you can also save lives.
Thank you so much for that. I am really, really, really excited about that video. I'm very happy with the way it came out. And a special thanks to Tina Taylor and Colin, who Tina did the directing and script for that. Colin did the voiceover work. So thank you both. Unfortunately, neither can make it today. So now I want to discuss the video with Barry a little bit, and we're going to answer some questions that got submitted. We got an awful lot of questions. So what I with some of them I'm going to ask verbatim, but most of them have kind of generalized and mushed a couple people's questions into one. And I know Barry has something he wants to say today. So Barry, thank you for being here.
Thank you, Melanie. The first thing, we were going to be taping this yesterday, and yesterday was the 73rd anniversary of my parents' anniversary, Cy and Judy Goldstein. And, I wanted to think about them and remember them because it was from their personal example that I learned the importance of helping others. And as I grew up, I thought it was just normal to have two good parents, loving parents, safe parents. And as I do this work, I find that that's too often it's unusual. Too many children do not have that huge benefit. And that's really why we're doing the work that we're doing. And it makes me just even more appreciative of Cy and Judy Goldstein and the impact they had on my life.
Oh, thank you for that. And you're absolutely right. We do work that is so sad and so deal with so much negativity. It is really important to remember there are good parents out there. There are good families. And that's the goal here. That's what this is all about.
And Melanie, what I'd like to do just to talk a little bit about the video. And the first thing, this is an exciting time at the Stop Abuse campaign. In the last, particularly several months, we have had a big increase in volunteers who are spending significant time helping us. That's where that video came from. And there's a lot more things coming as we work to change the broken system. If anybody listening to this has 6 hours a week or more, we would encourage you to reach out to us because we can always use more help, more assistance. And that video is so helpful because in a couple of minutes, it explains what the problem is in the courts and what can be done to change that. And as Melanie said, lots of protective mothers have trouble saying it in a few words or having a tool that they can share with their friends, with their family, with their lawyers, with anyone that they want to help. And so we think that video is going to be helpful. We are going to have more similar videos. I think the next one is going to be on scientific alienation theories. And so we are excited about this work and hope that we'll soon have some breakthroughs.
Okay. Yeah. Thank you very much, Barry. And yes, absolutely. We are always looking for volunteers. If anyone decides, hey, I think this is work I can do, you can send an email to info@stopabusecampaign.org, and we'll talk with you and see what you're comfortable doing, and see how it matches up with what we need. So, and you are correct, Barry. The next video we're planning on producing is about parental alienation. So that actually is the umbrella that a whole lot of questions we got fall under. So, why don't we talk about that a little bit? What is parental alienation? Why do we take the stance we take on it? Is this something that mothers can never make work for their case? What do we need to know about that?
Um, Originally, there was a theory called parental alienation syndrome that was concocted by Richard Gardner, not based on any research, but based on his personal experience, beliefs, and biases. And his beliefs included many public statements to the effect that sex between adults and children can be acceptable. And so it's not surprising that this bogus theory was used and continues to be used to help sexual predators get away with abusing children. And Gardner used the parental alienation syndrome, which he sent to self-published books to most of the courts in the country. And he used that to found the cottage industry of lawyers and mental health professionals, who it gives them something that they can use to help wealthy abusers gain custody. That's the purpose of these unscientific alienation theories. And he started by attempting to include parental alienation syndrome in the DSM-4, which is the compendium of all valid mental health diagnoses. And it was rejected by the American Psychiatric Association because there's no research to support it. And so what the cottage industry then did is they took PAS, which got a deserved bad reputation, and they tried to change the name instead of change what it was doing. And so they would call it alienation or parental alienation, and there are other names. And they wrote some articles to slightly modify it, but it's all based on the original parental alienation syndrome. And then the cottage industry plus male supremacist groups aggressively lobbied to include unscientific alienation theories in the DSM-4. I'm sorry, 5. That's the present compendium. And again, the American Psychiatric Association rejected it because there's no research to support it. And you would think that that would be the end of the court using it. I mean, for leading professional organizations to be saying this is garbage, why is the court continuing to use it? And one of the things I've heard judges say is, okay, there's no science to support it, but we know that some parents make negative statements about other parents, and so we don't need scientific research to allow this type of information or evidence in court. And that would be okay if they didn't, once they got over that hurdle, if they didn't then accept the rest of the unscientific alienation theory. One part of it is that it assumes that alienation is caused by mental illness. So they're diagnosing children, or they're diagnosing protective mothers as unfit because they believe in alienation or they're engaging in alienation. And, the fact is that by denying inclusion in the DSM-4 and 5, the American Psychiatric Association has made very clear this is not a mental health diagnosis. There actually have been a few psychologists and psychiatrists who have lost their license quite properly because they're diagnosing something that doesn't exist in the DSM or in reality. The other big problem is that alienation assumes that it is the most harmful thing to children. Now, in reality, there's plenty of children who hear parents, even in intact families, say negative things about the other parent, and it usually has very, very limited effect and short term. But the alienation theories assume that it's the worst thing possible. That's why it's had such pernicious influence in the court system. And, the reality is it doesn't. Domestic violence and child abuse shorten children's lives, result in a lifetime of health and social problems, are far more consequential. But in the broken court system, alienation has far more influence. And the other thing, we have a new study called the Myers study, and it hasn't gotten disseminated as much as it should because not long after it came out, we had the pandemic and, people were protecting their health and not, meeting and discussing, the research. But one of the interesting findings in the Myers study, and this is from the National Institute of Justice in the US Justice Department, so highly credible. They found that when a court believes that a father has been alienated, it is a huge benefit to the father's case and usually results in them winning the case. When the court believes the mother's claims of alienation, it has no effect on the outcome. What that means is that the way alienation is now used, it is a fundamental violation of due process and equal protection because it only helps fathers, not mothers. And that should stop the use of this. And just to go back for a second, fundamentally, the problem with these alienation theories is that it assumes that if a child doesn't like the father, doesn't want to spend time with the father, is afraid of the father, that there is only one possible explanation. And that is that the mother is alienating or coaching the child. In fact, that's the least likely reason for the child's reaction. Because if the father, in fact, was a good father, an involved father, a safe father, and the mother started telling the child things that the child knew was false, it would harm the relationship with the mother. But the alienation theories, which are designed to help abusive fathers do just that by assuming things, not by reality. Let me stop there because I think that's a rather complete answer.
Yeah, thank you. No, thank you very much, because that answer encapsulated a couple of questions, including one that I see with some regularity, which is from a protective mother who's saying the father is alienating against me. And one of the things you just it doesn't matter if you bring that up in court or not, because it's not going to work.
Well, and more than that, we don't want to use the same language that the cottage industry and the abuser groups use because we don't want to give it any credibility, because obviously these unscientific alienation theories have put a poison in the court system. It's a big part of why the courts fail to protect children so often. We prefer to call what you were referring to, which is fathers undermining the relationship between the mother and child as domestic violence by proxy. Because what it is really a continuation of the father's abuse of the mother, only they're doing it through the child. And unfortunately, what abusers have learned is that the best way to hurt a mother, to hurt their victim, is to hurt her child.
Okay, thank you. And that actually dovetails very well into the next question. This one's a little long, but there's a bunch of pieces to it, so it answers your answer will cover a lot of separate questions. My lawyer doesn't seem to believe that coercive control, emotional or psychological abuse can be proven or will make a difference. What should I ask when checking out attorneys? I want to ask if they believe in ACEs and are willing to bring that argument to the courtroom.
Okay, so the most common question that I receive is, where can I get a good attorney for a domestic violence case? And that's because there are very few attorneys that know what they need to know for it. And you don't learn it in law school, just as psychologists and psychiatrists don't learn about domestic violence in their academic training. And so the good thing is, we don't need attorneys to be experts in domestic violence. What we need is for them to be able and willing to present evidence of domestic violence and of the research. And we can provide them that information, but they have to be willing to listen. And there are some serious ethical issues for attorneys. Many protective mothers have talked about their attorneys refusing or discouraging presenting evidence of domestic violence and certainly the research. And there can be a good reason for it. They may know the judge and believe the judge doesn't want to hear it and that the judge might retaliate. And it really says something about the broken court system that could actually be happening. But very often, it's really a conflict of interest for the attorney. What the attorney is really concerned about is that if he or she presents evidence that the judge doesn't want to hear, evidence that says we should take domestic violence and child abuse more seriously, the attorney is afraid that the judge will be angry at the attorney and that will negatively impact other cases. Ethically, an attorney cannot do that, because what he's doing is undermining the case of his client, who's a protective mother, in order to help his career and the cases of other clients. And so it's not just that he or she needs to drop out of the case, but he should not be accepting cases involving issues of domestic violence and child abuse if he knows or she knows that they're not willing to present this evidence. Because it's really unfair for them to take money from the protective parent, who often has very limited resources, use that up and then drop out and leave the client in a much worse situation. I think the other part of the question reminds me that fairly recently, the Stop Abuse campaign posted an article that talked about he said, she said, because a lot of court professionals who do not understand domestic violence and child abuse dismiss it as he said, she said. And the idea is, well, they say opposite things. I can't tell who to believe, so I'll go on to other issues that are less important. And in the article, we talk about the fact that there's a lot of available evidence that will show we should believe the protective mother, if only we know what to look for, if only we understand the significance of the evidence. And so when a court professional makes reference to he said, she said, the professional is really saying they don't have the knowledge and training they need for abuse cases.
Yes, absolutely. Thank you for answering that. That was a big question, but it touched on a lot of things, and actually brings me to another one. Um, how will courts learn characteristics or behaviors of sex abuse perpetrators? My judge doesn't know anything about child sex abuse and is accusing me of coaching or alienating my child.
You know, in our country and in the custody courts, our response to child sexual abuse is nothing short of a calamity. The ACE research tells us that by the time children reach the age of 18, a quarter of them will have been sexually abused. And Melanie, I must tell you, I work with tons of research, all sorts of statistics. There's no statistic that bothers me more than that we allow a quarter of our children to be sexually abused when we could protect them is really horrendous. And the fact that so many of our children are sexually abused, really tells us that our practices need to be fixed. And we've seen that. We've had one sexual abuse scandal after another, be it the Catholic Church or the Boy Scouts or Penn State or Olympic athletes or, individual schools, et cetera, et cetera. And it's because we're not taking it seriously, because we don't know what to look for. But the biggest problem is that we don't believe women and children. The Ballas study tells us that in contested custody cases, mothers make deliberate false reports less than 2% of the time. And the Saunders study tells us that court professionals who do not have the specific domestic violence knowledge that Saunders found is needed tend to focus on the myth that mothers frequently make false reports and unscientific alienation theories. What that means is that when we see lawyers and evaluators and other court professionals focusing on the mother's a liar, the mother's coaching the children, alienation theories, they are telling the court nothing about the case and everything about their lack of qualifications. The Myers study found that when mothers raise concerns about child sexual abuse, which, as we said a moment ago, only 2% are deliberately false, the courts disbelieve 85% of those cases. And if the father uses unscientific alienation as a tactic, then the court believes only 2%. That means that a very, very large majority of cases, the courts are getting wrong. And one of the things I think they're missing is that when a mother raises concerns about child sexual abuse, there are several possible reasons. The most likely reason is that the child is being sexually abused, by the father or whoever, or some other perpetrator. It's possible that the child is acting out, because they've been exposed to pornography or even sexual behavior in person. It's possible that there are boundary violations, which are unintentional and can easily be corrected, but could cause the child to act out in ways that are similar to child sexual abuse. It could be that the evidence is equivocal because it is hard to prove child sexual abuse, particularly with young children. It could be that the reports are false but made in totally good faith. The least likely explanation is a deliberate false report or coaching by the mother. And yet, in most custody court cases, the only things they consider are it's true and they have a very high standard to accept that, or the mother's coaching and how can we punish her. And that's a big part of why the courts get these cases so wrong. So for the mother who wrote you the question, it's really important to educate the court, to say to the court that a lot of the standard practices that courts are using cause courts to disbelieve true reports. And not only does that mean that the child won't be protected, it means the child won't get the help they need, and it means that the child will be silenced. So, and we need to talk about, exposure to child sexual abuse often destroys the child's life. So the consequences are really serious. You'd think the court would err on the side of protecting children, but they're doing just the opposite. And one more thing I want to mention, for young children, often a very good response is play therapy. And the reason for that, the abusive side will say, why do we expose children to things like this? But play therapy, they're going to meet someone who they're probably going to like, and they're there to play and have a good time, so they will enjoy going. It's not something we're putting them through. It's a pleasant experience. And especially important for court cases is that the children will reveal whatever they need to reveal in their play, in their artwork, without knowing that they're doing it. No one can coach them how to paint a picture or play with blocks or whatever. So that eliminates the issue of coaching, which is really helpful in a system that wants to assume coaching.
Thank you for that, Barry. Thank you. So another question you've got here: why do judges overlook long-term patterns and resume 50-50 or whatever, some custody situation that gives an abuser a lot of access to the child when the monitored abuser has behaved themselves for a few months?
Okay, there's a few things there. The first thing is, one of the reasons that domestic violence advocates and other experts know so much more than court professionals about domestic violence and child abuse is that we look for patterns. We see the same thing over and over again, whereas the courts are constantly making decisions that theoretically could have occurred in an individual case, but are extremely rare. And let me give you an example because I think it fits here also. I find in almost every case that I'm dealing with involving domestic violence in a custody dispute, the father either wanted or demanded that the mother provide most of the child care during the relationship. And in any other type of litigation, that would be understood as an admission by the father that she is a good parent. She wouldn't want her caring for the child if she wasn't a good parent. And then the mother reports his abuse, ends the relationship, or maybe they both end the relationship. And all of a sudden, the father is saying she's an unfit parent. Now, what are the chances that she suddenly became an unfit parent because the relationship ended or because she reported his abuse? I mean, that is extremely rare, but that's really the finding in most of these cases because the courts aren't thinking of that. And, when I just say what I just did, attorneys that I work with, it makes sense. It's logical, but no one never thinks about that unless you're dealing with a DV expert. And these patterns can make it much easier. There's another part to your question I want to talk about because I just found something that I think is important about the high conflict approach that courts routinely make. Now, we've long known that that's a mistake based on the research. You know, most custody cases are settled more or less amicably. There's about 3.8% of cases that require trial and much more. And the research shows that a very large majority, between 75 and 90% of these cases, are really domestic violence cases involving fathers who believe she has no right to leave. And so they're using custody to regain control and to punish her for leaving. That's what these cases are. The courts don't know it. So high conflict assumes that both parents are angry because of the end of the relationship and that they're acting out in response to that and hurting the children in the process. In reality, as we just said, most of it is really domestic violence cases, so that the mother's response of trying to protect her children is viewed as negative or harmful rather than exactly what good mothers should be doing. But what I think is interesting, high conflict is based on the stereotype of the vindictive woman. It's assuming that the mother is angry because the relationship ended and is acting out in bad ways. That's a sexist stereotype. It's gender biased. So it's not just that high conflict approaches are wrong on the facts and the research, but they are also sexist and biased. And I think when we start talking in those terms, it makes it even more important that the courts drop that approach, which is really so biased in terms of the court procedure, because immediately, before they make any effort to determine the issues of domestic violence and child abuse, which are highly dangerous and the most important issue in the case, they're immediately trying to do shared parenting and cooperation and communication and forcing the victim to interact with her abuser, which is very dangerous. And any objection from the mother who's been abused by the father, is viewed negatively on the mother, not the father. Because remember, it's his behavior that made her afraid. And one of the common examples of gender bias is blaming women for the actions of their abuser. And the courts are starting with that. And that prejudices the whole rest of the case.
Okay, thank you very much for that, Barry. So one question that's going to kind of wrap us up a little bit, but so what's the answer? How do we fix this big, complicated, deeply entrenched system that endangers children and women?
Okay, I'm glad you asked that one. That's what we want to focus on, because I think what's really harmful is that we know how to stop this. We could make our children safe. And the Safe Child Act is something that I put together. It's a comprehensive plan based on the research, based on our understanding of abuse. And if we use these practices, the children are going to be safe. We're not going to have the 58,000 children sent to live or to spend time with dangerous abusers. We're not going to have the nearly 800 child murders as we had in the last 10 years. Kyra's Law, which was recently introduced in New York, is named after Kyra Franchetti, who's one of those children who was murdered. She was only 28 months old. And, you look at the case, it was easy to know the father was in danger. But the bias in the courts to keeping even dangerous abusers in children's lives prevents them from protecting children. And we've had numerous situations where judges and court administrators are asked, what did they do after a murder of a child where the court, gave the father access? And what we found is the courts just dismissed this as, an exception, and it's not. And because they dismiss it, they're not doing the reforms that are needed, and they're just not open to it, which means that the legislature has to act if we're going to save children. And just quickly, the Safe Child Act says the health and safety of children must be the first priority. I mean, it seems obvious, and yet they don't do it. They could do it with present law, but they don't. The Safe Child Act promotes the use of current scientific research like ACE and Saunders. Here we have peer-reviewed research from the Center for Disease Control, from the US Justice Department, that have the best research. And the courts aren't using that, but they're using a bogus alienation theory based on no research, but that was designed to help abusive fathers. I mean, you can't make it up that they're doing these things so wrong. The next thing is an early hearing limited to abuse issues, which of course are the most important issues in these cases. If the father abused the mother or child, we know what the outcome is. We don't need to allow the kind of distractions that abusers put into the case to try to delay it, to try to bankrupt the mother, and to try to avoid accountability. We also want to get training and really retraining for judges and other court professionals. Over the years, the judges have heard a lot of misinformation. Many of the standard practices, like high conflict, that courts are using are proved to be mistaken by the ACE research and the Saunders study. And there just doesn't seem to be any method within the court system to take a look at the research, to look at the unspeakable consequences, and to change, to consider doing things based on the research. As we've said before, the pandemic has told us you got to listen to the scientists. That's what this research is about. Without listening to the scientists, we lost so many people in our country, and we're losing so many children in the custody courts.
Thank you so much, Barry. Thank you. So, Safe Child Act, that is our biggest legislative push right now. We are trying to get this. This is a bill that needs to get implemented in all 50 states. Right now, New York and Pennsylvania have it introduced in active session, and it's got the most momentum in New York right now. So even if you don't live in New York, you should care about this, because when this gets passed anywhere, it's going to make it much easier to get it passed everywhere. So some things you can do. We have a page on our website, www.stopabusecampaign.org, about Kira's Law. We have that article is also on our Facebook page. Take a look at it. Embedded, if you live in New York, you will see embedded, well, no matter where you live, you'll see embedded in it a button that you can click on to send something to send emails to your legislators if you live in the state of New York. If you live in the state of New York, do that. It's going to ask for your address. You put it in. It's going to guide you through these emails. You send them out. This really and truly is working. We already have confirmation of that. I mean, not just working like the emails are going, but they're getting read. Legislators are paying attention to this. This is huge. If you don't live in New York, there is a petition you can find that you sign it. That's going to send an email to the governor of your state. This is going to be a little slower and a little harder, but it still is worth doing, because this is your chance to educate your elected leaders about this issue. Most of them have never heard about it. We are always in need of volunteers. As Barry said at the beginning, if you have a couple hours a week, you can send us an email at info@stopabusecampaign.org. And if I know this is a very difficult time financially for a lot of people, but donations let us do our job. Let us educate legislators. Let us reach out to people and provide resources for everyone. So you can donate to us you can donate on the website as well. We have another event scheduled for April. We are going to be showing the documentary What Doesn't Kill Me, which is specifically about the family court crisis. We're going to have a live panel discussion, which is really interesting, and we've got some great people signed on to that. So stay tuned. If you're not currently liking our Facebook page, please do that. Please stay, that's the best way you're going to be able to communicate with us and get quick emails and stuff like that. Sign up on our mailing list. But pay attention. You've got a lot more going on right now, and this 2021 is going to be a good year. Things are looking up for us. So we're all work together, and let's protect some kids. Let's try to fix this mess. Thank you so much. Thank you to Andrew. Thank you to Barry. And thank you to all of you folks.